I was then instructed that the procedure for visiting with the client had changed and that the public visiting room had now been converted into an attorney-client visiting room only, and that I would have to converse with my client because of COVID-19 policies through this public now visiting room. So, well, that I have a box of documents. I have 16 gigabytes of information I need to go through with my client. I need to physically see them. They said, no, you're going to have to go to this. I said, well, I'm already here. I need to visit with my client. Is it confidential? I was specifically told multiple times that morning by that deputy that my communication with my client would be confidential and not recorded.
On March 30th?
Yes, Your Honor. They're in the waiting room multiple times. I might not be the most seasoned attorney, but there is absolutely no way that I would ever get on a phone thinking that it was going to be recorded and have incredibly sensitive conversations with my client regarding their defense. They told me that the room had been changed at that point to a attorney-client visitation room only, and that the recordings were not going to happen.
That was Mark Means, the attorney for the so-called cult mom, Lori Vallow Daybell, angry. And that was a while ago because in order to speak with his client, he had to use the visitation booth because of COVID, and his conversation with his client was recorded by law enforcement. He was outraged, rightfully so. So as a result of that, today, back in a hearing, it was a Zoom hearing, he wanted to give Lori a cell phone so he could have those private communications. There was also some arguments about him getting his hands on the prosecutor's notes regarding some witnesses. Let's take a look at how it all went down in East Idaho.
Mr. Means, are you ready to present argument on the motion?
I am, Your Honor. My client has been in the Madison Detention Center since approximately February to February, so we're dealing about 12 months. Over the course of this 12 months, approximately 6 of these months, I have been denied access to my client to visit with her in an attorney-client room. We've had at least 3 recorded phone conversations after multiple representations that have not been recorded that have been leaked in one way or another. We're also in the Madison Detention Center dealing with video cameras that are front and back that are recording the communications. There's an entire clear glass wall where deputies are outside able to watch the communication and the interaction between the clients. Anytime I call my client, she has 2 options. One, she can stand at the desk with the deputy, as I cited, with about 2 feet handcuffed to a phone call with the deputy standing right next to her, or approximately 15 or so feet away. She's on a recorded phone line through Tailmate, and obviously we've had issues with that before, cited, I think, by both sides. Mr. Daybell's been incarcerated for 9 months. He's had 0 alleged allegations of recorded phone calls, 0 interference with his client-attorney privileged communications, 0 denial to see his client, 0 video cameras recording him, and 0 phone calls with deputies around him. This is obviously drastically different when we're dealing with roughly the same facts and the same charges. We're treating them differently. I think there could be an argument for potential gender discrimination. And again, I'm trying to avoid that in the future, but we do have an issue here with the access or fairness of the process. I have to point out that each of the time that what appears to be arbitrarily denied access to my client to meet with her in an attorney-client room, it coincides with 1, my motion to reduce bond that brought up the recorded phone calls before, and 2, the motion to disqualify the prosecutor. I think a cell phone provided at the expense of the defense with some severe limitations on the cell phone would be appropriate. And what we have here is at least 3, maybe 4, based on the representation here, of some recorded phone calls that in one way or the other, I don't think we have to have that argument today as far as who's at fault, one way or the other has made their way to the prosecutor or to the detectives in this case. If we allow them to continue to have that opportunity after I'm being told that I'm not being recorded, and it happens again, we're going to be in an awkward situation where potentially the case will be requested to be dismissed. And I don't think the prosecutor wants to take that risk. What we would propose is, one, that the court allow me unrestricted access, as I should have, to my client in the attorney-client room. Two, that these video cameras be turned off. Three, that she be given a cell phone that she can use much like the laptop to review the evidence in this case, limited to my phone number only, no internet access, no text message, none of these type of things, I think, which the prosecutor expressed some concerns over. And it would be my obligation to find and make sure that that happens. If we're able to do that, I think it benefits the attorney-client privilege and makes it more realistic and the ability to prepare a fair defense.
We do object to the idea of just turning off security cameras in general. I've never received a request like that from any other attorney. And so we would ask if he can work with the jail to make sure they're not being watched, but to turn off the security cameras is overboard. In terms of the cell phone, Your Honor, that this is I've never seen a request like this. I've never seen another attorney have these issues.
Mr. Means, you are allowed to use the attorney-client room unless the jail has some overriding policy that on a particular trip, the room's not available. So I suggest you make a plan with the jail and advise them of when you're going to be there to see if they can sort of, I don't know that they reserve the room, but be advised that the room, you'd like to use it, and that will be allowed. The other issues involving the video and the cell phone, in terms of the video, there are security reasons why video should be in place for both attorneys and clients in the jail. The jail sets those policies. I'm not going to make any order that the video be turned off. Clearly, any audio recordings are not allowed in the attorney-client privilege communications within the jail, since those would violate that privilege if there was audio recordings. I understand it inadvertently happened before in this case, and I just asked the state to make every effort to make sure that that issue doesn't come up again. And then finally, on the request for the cell phone, I'm going to deny that request.
It is mandatory of the prosecutor to produce any and all evidence that tends to negate the guilt of the accused. And these include statements of witnesses, prospective witnesses, and other things. Rule 16 is clear. These statements of these witnesses, including Mr. Wood himself as a witness in my case, are relevant to this matter. The people that we listed specifically in the discovery request, as I mentioned, are the witnesses and or the defendants in this case, which some evidence has been produced and some of these individuals has been identified. The state is attempting to shoehorn an objection and a non-obligation into a work product doctrine, citing that there are notes or memorandums. We don't mention notes or memorandums in our discovery request. We ask for the text messages, emails, conversations, voice recordings, whatever. We know for a fact, based on the transcript that was provided to the court, that Mr. Wood has had personal conversations with Colby. We know for a fact with Summer Shiplet. We know for a fact, based on other evidence, that he's had conversations with the Woodcocks. He has made himself a witness in this case. And if the court doesn't grant this motion, we're on a dangerous precipice that says we can deliver properly discovery requests, and they can be outright ignored and not brought to the attention of the court until the propounding party brings a motion to compel. That's a problem and a dangerous precedent.
Quite frankly, Your Honor, is that this motion to compel and the underlying discovery request are totally improper, are illegal, and they fell on their face for 4 reasons. The request for discovery is absolutely outside the scope of Rule 16 and Idaho law. The request for discovery blatantly violates Rule 16's work product provisions or provision. 3, it's an attempt to turn a mere 8-day delay into authority for the court to grant an improper motion that has no grounds in law. And 4, it's attempting to relitigate issues already decided by the court.
What is your response to the request to have that information provided?
Your Honor, I agree that statements by witnesses need to be provided. We're not saying they don't. Every conversation with a prosecutor and a potential witness does not produce a statement.
But have you, in fact, gone through that list of names and determined or provided that to Mr. Means in terms of whether or not you've discussed that, whether or not those people have relevant knowledge of the facts of the case?
You're not, we have provided countless police reports that have the statements of those witnesses.
We have the right to those statements, whether they're his or whether they are the prospective witnesses or the actual witnesses. We have not received those to date, Your Honor. So we would ask again that the court grant this motion, give a shortened, reasonable time to respond, and consider the argument for sanctions as a matter to deter this behavior in the future.
This request for discovery is absolutely outside the scope of Rule 16. And I would note, it's not just this list of people he's produced. He says all persons I've ever conversed with. So if
Converse with regarding this case.
It's my turn to speak now, Mr. Means.
If you talk to a lot of people, that obligation is on you, not on me.
By his own writing,
Hold
by
on a
his,
second. Both of you, we're making a recording here. We also have a court reporter who has to transcribe this. Mr. Means, I'm going to admonish you, do not talk over the top of someone else.
by his own request, if a friend said, "How'd you feel about that hearing?" in a text, and I just said, "Oh, it made me tired," that would be something I'd need to disclose to Mr. Means. That's ridiculous, and it's just an attempt to look away from the facts of the case. The law absolutely differentiates between an attorney preparing their case and collecting statements and witnesses making statements. I would note, Your Honor, the work product. He says he wants my emails. He wants text messages. Correspondence is part of Rule 16, and Rule 16 is adamant. Disclosure must not be required.
I will grant the motion in terms of requiring that the state provide a response to the question as to whether or not the prosecution has discussed the case with those persons identified in the list that starts on line 16 on page 2 of the discovery request. I'm going to make an exception and not require a response to parts 25, 26, and 27 of the list, as I find those are too broad and not reasonably calculated to lead to discoverable evidence or relevant evidence.
Things are getting personal out in Idaho. Unbelievable.